afternoon, ladies and gentlemen, colleagues. I'm sure many of you will be somewhat familiar with the practice of intellectual property-rich companies in incorporating and establishing specialist companies to hold their IP rights. These companies are sometimes known by their acronym IPHCs, and normally they are incorporated in jurisdictions like the Cayman Islands and Switzerland. Indeed, it's my understanding that McDonald's Corporation has recently established a Swiss corporation to handle its intellectual property rights. Very often, the decision to set up an intellectual property holding company is very much tax-driven. The purpose of my presentation this afternoon is to, in a sense, to act as a cautionary advice that in thinking about tax, you should not forget about the IP implications. In other words, ask yourselves, in setting up in a low tax jurisdiction, will you be able to effectively manage your intellectual property portfolio? Now, for the purposes of my presentation, I'm going to confine myself just to trademarks and designs. I am very conscious that some countries offer very attractive incentives to patent-rich companies. Indeed, the United Kingdom has just recently enacted legislation which will offer patent owners a very favorable 10% tax rate. In going through, or taking you through, how you can effectively run and manage a trademark and design portfolio through a European intellectual property company, there are a number of things that I will deal with. And forgive me, Edmund has previously touched on the CTM and the Imagery Protocol systems, but and forgive me if there's an overlap, I'll touch on those again because I think it's important to deal with these in the context of running an intellectual property holding company. So we look at the community trademark, the Madrid Agreement Protocol, the link between the two systems. I'll also deal with the European Community Design, and again, an overlap between the Registered Community Design system and the CTM system. Taking all that into account, I'll then look at notable intellectual property holding jurisdictions within the European Union. And lastly, I'll provide an overview and some suggestions as to where you, as an intellectual property-rich company, might choose to incorporate your intellectual property holding company. To just mention something slightly about intellectual property holding companies. Their main purpose is to provide for efficient management and monetization of intellectual property rights. So again, we're talking about patents, trademarks, and designs. And in the European Union, there are numerous countries that actually offer quite attractive tax advantages through a locally owned intellectual property holding company. And I'll mention those countries as I go through my talk. Obviously, there are special factors that apply when placing trademark and designs within an intellectual property holding company incorporated within the European Union. The message that I really would like you to take away from this is to ensure that a trademark and design portfolio is managed to its maximum advantage. Care does need to be taken where to incorporate that intellectual property holding company, and you'll understand the reasons as I go through my slides. Again, another message that perhaps I'd like you to take away from this is a country that may be attractive from a tax advantage may not necessarily facilitate an effective IPR management strategy. Indeed, not necessarily always a good idea from an IP point of view to go for the lowest tax jurisdiction, because you may well find that it would be difficult to manage your IP rights within that company. The decision to locate will depend on a number of factors, such as existing commercial presence within the European Union, legal systems, be it common law or civil law, and also whether the intellectual property holding company jurisdiction is a member of the Eurozone. And again, you'll understand this as I go through my slides. So turning first to the community trademark, and Edmund touched on the community trademark in his talk. Perhaps one of the most effective ways of owning, enforcing and managing a centralized trademark portfolio within the European Union is by making use of the CTM system. What is the CTM? Essentially, it's a unitary trademark right that provides protection in, I say, all 28 member states. There are currently 27. Croatia will shortly join in around June or July of this year. So that will bring the number of member states up to 28. The holder of a CTM is given an exclusive right to use that particular trademark throughout the European Union and to prevent others from using, without consent, identical or similar signs in relation to identical and or similar goods and services. Indeed, in some cases, it's possible for the holder of a CTM to seek temporary relief, most notably an injunction, against suspected infringers by way of an injunction through a community trademark court. What's the community trademark court? A community trademark court is a court in whatever member state that is specifically set up to handle disputes relating to community trademarks. If granted, that injunction may well be enforceable throughout the European Union. So that means if, for example, you may decide that you would seek an injunction through the German court, potentially that injunction could be enforced throughout all 27 member states of the European Union. A CTM, it's important to remember, is an all or nothing right. It's not possible for a CTM to cover some European member states and not others. It can be challenged by the holder of a prior right from any European member state. Important to bear that in mind. If the CTM is cancelled, also very important to bear in mind, it's cancelled for the whole of the European Union. However, the owner of that unsuccessful CTM always has the option of converting it into separate European rights. And the significant thing is that the converted applications can date back to the date that the CTM was originally formed. The significance of placing for example, CTMs within the European intellectual property holding company really becomes apparent when it comes to enforcement. And the regulation which governs the CTM has a specific article which deals with jurisdiction in cases of infringement disputes. I've highlighted the main provisions of that article here. Essentially, the rule is courts in the EU member state where the defendant is domiciled or has an establishment has jurisdictions in case where that CTM is infringed. If you can't satisfy that limb, you will move on to the other one. If a defendant is not domiciled within a EU member state, then the courts of the member state where the defendant has an establishment will have a jurisdiction. If you can't satisfy that limb, if the defendant is not domiciled or has an establishment in an EU member state, then the courts where the plaintiff is domiciled will have jurisdiction. If the plaintiff is not domiciled within an EU member state, then the courts of the EU member state where the plaintiff has an establishment has a jurisdiction. And lastly, the default position is if neither the plaintiff nor the defendant are domiciled or have an establishment in an EU member state, the courts where the European Trademark and Designs Office is based, otherwise known as OIM, and in this case it's based in Spain, so Spanish courts would have jurisdiction. The significance of this will become apparent to you as I run through various So if we look at perhaps the first scenario. So let us say you have the infringer is domiciled in the United States, but that infringer, the defendant, doesn't have a commercial presence in Europe. Using the rules of the CTM regulation, you would then say, well, where is the plaintiff based? And let us say that you decide to set up an Irish intellectual property holding company. Obviously, the Irish intellectual property holding company would be based in Ireland. So in that case, the Irish courts would have jurisdiction because the plaintiff has a domicile in Ireland. Scenario 2, again, we're looking at defendant domicile in the United States, has no European commercial presence. But in this case, the plaintiff is a Swiss-based intellectual property holding company, but doesn't have a commercial presence in the European Union. What's the default? Spanish courts will have jurisdiction because neither the plaintiff nor the defendant has a domicile or commercial presence in the European Union. Scenario 3, defendant is domiciled in the Cayman Islands but has a commercial presence in Germany, therefore German courts have jurisdiction because the defendant has a commercial presence there. The same, more or less the same provisions apply insofar as the CTM is considered an object of property. And the relevant article in the CTM regulation which deals with this is Article 16. It essentially stipulates that a CTM as an object of property shall be dealt with if it's a national trademark registered in the European member state. So in other words, it's turning to the law of the country where where the owner of that trademark has its seat or domicile or has an establishment. Now, where those two conditions are not met, a CTM shall be dealt with as an object of property in the country where the European Trademarks Office, OHIM, has its establishment. So Spanish law would apply in that particular case. So obviously you're all asking yourself, well, okay, how is this of significance? It's of importance because if there's an issue regarding, let us say, the transfer of a CTM, you need to ensure that that issue or dispute is governed by the law of a country where it has a preferential legal system. For example, it's suggested that if the trademark owner is a US corporation, US being a common law country, you may prefer that any dispute relating to the CTM is also heard in a common law country. And in this case, it would be either Ireland or the United Kingdom. It may also be of significance if, let's say, you're using the CTM as a security interest. If there's any dispute, the same implications apply. Okay, so I've dealt with the CTM. Moving on now to the Imagery Protocol. Essentially, it's a centralized system that allows for the protection of trademarks on an international basis by means of a single application filed with the World Intellectual Property Office in Switzerland, in Geneva, Switzerland. The significant thing about the protocol is the connection between it and the CTM system, whereby you can actually designate the CTM as part of your Madrid application. If you do that, you avoid the need to separately designate those countries in the European Union where you wish to protect your trademark. It's examined in the same way as your CTM designation is examined in the same way as if it would be filed directly with OHIM. And unless an objection is raised by OHIM within 18 months of filing, or the CTM designation is opposed, protection is automatically granted. Even if a CTM designation is rejected or successfully opposed, it's important to bear in mind it's still possible to convert it into separate European member state designations with the same filing date as the CTM designation. As I mentioned earlier, the two systems are linked. And another feature of the two systems is that it's possible to use a CTM as the basis of an IR. So you're taking your IR application and you're using the CTM as the basis of that international application. Important thing to bear in mind, the link facility in that situation is effectively only available to European domiciled businesses or businesses with a real and effective commercial presence in Europe. So, a corporation without a European domicile or a real and effective commercial presence in the European Union could not use its CTMs as the basis of an IR application. However, you can get around that by placing your trademarks in a European incorporated company, for example, an Irish company. Businesses with no real and effective commercial presence in the European Union can overcome the hurdle of this link facility. Important thing to bear in mind, one of the features of the link between the CTM and the Madrid system is international registrations can be centrally attacked if the base registration upon which that international application is filed is successfully challenged during the first 5 years of the international application. So you need to ensure that the application or the registration upon which you're basing your IR on is not vulnerable to attack. If it's attacked within the first 5 years of filing your IR, the whole IR will fail. Interestingly, if, for example, an Irish intellectual property holding company bases in Madrid on what's called a pre-1996 Irish registration, you get over the potential of a successful challenge, because pre-1996 Irish trademark registrations are immune from invalidity attack on grounds of non-distinctiveness. Now, of course, they can still be cancelled if they fall into disuse for a continuous 5-year period. So if you know that you have pre-1996 Irish registrations and you want to file a Madrid IR application, well worth possibly using that Irish registration as the basis of your IR. Obviously, there are times when it's not a good idea to designate the CTM as part of the Madrid system. It's not possible to seek international protection for a list of goods or services wider than those of the base application or registration. And trademark owners seeking protection in Europe for goods or services broader than sought in their own home country would be better advised to file a standalone CTM outside of the Madrid Protocol. For example, I'm aware that the USPTO, the United States Patents and Trademarks Office, is quite strict when it comes to the list of goods and services that are used as part of a US application. Unlike the European Union, where you can tend to file broader specifications. So in that situation, it might be better for a US corporation, rather than using their US application or registration as the basis of an IR, that they just file a CTM separately. You, of course, can separately designate European member states as part of a Madrid application if the owner still has the option of an option of separately designating those European countries where trademark protection is desired. As a CTM and corresponding designations in an international registration can potentially fail in their entirety, it suggested that having numerous separate European registrations for the same trademark provides a little bit more security. And there is, of course, a downside to that, and that is essentially it can tend to be more costly, and it produces an administrative burden in terms of management. Significantly, also, if you decide to go with separate EU national registrations, in some countries, a domestic trademark registration provides a defense in the case of an infringement claim by the holder of an earlier trademark. There's some doubt now as to whether those the two countries that come to my mind with this particular defence are Ireland and the United Kingdom. There's been a recent case before the European Court of Justice where the Advocate General has questioned the validity of those national provisions. So I wouldn't concentrate too much on that particular defence. Of course, if you choose to designate just the CTM as opposed to filing or as opposed to designating your EU national designations, you'll only have to deal with OHIM in the event of an objection and or opposition. Whereas if you designate in separate member states, you're potentially having to deal with objections from each of those member states. Not forgetting designs. Of course, again, the European Union has introduced a centralised way of protecting designs. And in Europe, designs can be protected, I'm sure you're not surprised, if one, they're novel, and two, have individual character. And indeed, one of the most effective ways of protecting designs in the European Union is through the community design system. And in Europe, a community design can be protected in either its registered or its unregistered form. In its unregistered form, a community design is protected for a period of 3 years from the date it was first made available to the public within the European Union. It allows the holder to prevent third parties from using either identical designs or designs that have the same overall impression on an informed user. However, it can only prevent direct copying of the protected design. So, you're much better to go for a European registered community design. It allows its owner to prevent the use of identical designs or designs of the same overall impression, even if those designs have been innocently created. So that's the main difference between unregistered and registered. The RCD system is effectively a deposit system whereby the application is filed and registration is granted shortly thereafter. In my experience, it's normally within 3 to 4 weeks of filing. The only time you will really get an objection from the European Designs Office, happens to be OHIM as well, is if your representations if they don't comply with the requirements of the designs regulation. Otherwise, there's no examination as to novelty or individual character. It's enforceable throughout the European Union, and like the CTM, can be used as a tool to prevent the importation of counterfeit goods into the European Union. Remember, I mentioned the possibility of getting a pan-European injunction. In theory, you can also do the same in the case of a design infringement. Important to bear in mind, if a third party successfully challenges the validity of the design, it falls for the whole of the European Union. And unlike a CTM, it's not possible to subsequently convert it into national registrations. So that's it. You lose your RCD. Of course, you may decide as an alternative to filing an RCD, it would be better to seek separate registration in European countries where protection is required. And indeed, design law has been harmonised throughout the European Union, so the requirements of registration are effectively the same in each EU member state. Again, seeking separate registrations is costly and administratively cumbersome. If you do decide to go down the national route, one advantage is that anybody wishing to challenge the validity would have to bring separate invalidity challenges in each country where the design is registered. There's an overlap between the RCD systems and the Hague Convention, which Alan mentioned earlier this morning. Looking at the overlap between the CTM and RCD systems, both can afford protection to certain types of designs, such as logos and graphic symbols. It can take up to 9 months for a CTM to be registered, whereas filing an RCD may give you a quicker route to protection for things like logos and designs and graphic symbols. As I mentioned earlier on, you could get your registration within 2 to 3 weeks of filing. Cautionary note here, legal advice should always be sought from European Intellectual Property Council before pursuing the route of maybe using a CTM and an RCD, in that a pre-filed CTM, and by pre-filed I mean if you file a CTM before your RCD, it obviously may destroy the novelty of your follow-on RCD, so be careful. Nationals that are members of the Hague Agreement can obviously designate the European Union in the same way a CTM can be designated as part of a Madrid But it should be noted, not possible to use an RCD. Unlike the Madrid Protocol, where you can use a base trademark application or registration, it's not possible to use an RCD as the basis of a Hague designation. So, taking all that into account, and we've looked at the CTM and RCD systems. So you've decided, right, you want to incorporate an intellectual property holding company to essentially manage your RCDs and or your CTMs. What are the most notable intellectual property jurisdictions within the European Union? We're looking at Cyprus, Ireland, Luxembourg, Malta, Netherlands, Switzerland, and the United Kingdom. Some have more advantageous attractions than others. I would always ask myself, okay, which of the countries are members of both the CTM and Madrid systems? And you'll see there from the table that most countries are members of both. Malta, not a member of the Madrid system. Bear that in mind. Also, the CTM is not a member, Switzerland is obviously not a member of the CTM system because the CTM just covers the European Union member states. Look at Hague. There is now the connection between Hague and the RCD system. Some countries indeed are already members of the Hague Convention, Luxembourg being the best example. Ask yourself, what legal system are you most comfortable with if you're a trademark or design owner? Some countries that operate the common law legal system, so India, companies would be familiar with that, Ireland, the United Kingdom. Cyprus offers both the common law and civil law systems. And, of course, the United Kingdom. Another factor you should always take into account is ask yourself, if I choose to incorporate an European intellectual property company, is that country where the company is incorporated a member of the Eurozone? Why is that significant? Because if you're going to be filing CTMs and RCDs, you're going to be paying the fees in euros. So looking at the countries here, where obviously most of them are members of the Eurozone, with the exceptions of Switzerland and the United Kingdom. Lastly, and I would say lastly, you look at what kind of rates are offered. And you'll see there's quite a variation there. Cyprus and Ireland, 10%, 12.5%. I would say Ireland, you can actually get that down to 2% if you use the amortization rules effectively. You'll see one of the lowest rates is offered in Luxembourg. Another factor which I haven't mentioned in the table is what country has the most double taxation agreements. For example, in my view, the two most favourable countries, Cyprus and Ireland. Cyprus has about 45 double taxation agreements. Ireland has 65. And always ask yourself, you as the intellectual property owner, does my country have a double taxation agreement with the country where I'm going to incorporate my intellectual property holding company? So I've put out some strategies here for you. So let us say you're an Indian intellectual property owner. The majority of your business in Europe is within the Eurozone countries. You have a newly established presence within the European Union, but unfortunately India is not yet a member of the Madrid Protocol, and India has a common law system. I would suggest that you incorporate a company in Ireland. You incorporate an intellectual property holding company to hold your trademarks and designs within Ireland. Why? Ireland is a member of the Madrid Protocol, therefore any Irish-based intellectual property holding company can own and file Madrid applications. An Irish-based intellectual property holding company can use CTMs it holds as a basis of a Madrid IR application. Ireland has the same legal system as India, and also significantly Ireland is a member of the Eurozone country. So there are no currency downsides when an Irish intellectual property holding company files CTMs where the fees are in euros. And lastly, Ireland has a double taxation agreement with India. Scenario 2, Swiss-based IP owner. Majority of business In Europe, within the Eurozone countries, Switzerland is a member of the Madrid system. Switzerland has a civil law legal system, but notably, Switzerland's not in the CTM system. I thought some time about this, but I came to the conclusion that it's probably best for such a company to actually use an intellectual property holding company based in Switzerland, like McDonald's does. It's a member of the Madrid Protocol, or Madrid Arrangement. Therefore, it can own and file Madrid applications. It can certainly designate CTMs as part of its IR application. But significantly, a Swiss-based IPHC will probably find it difficult to use CTMs it owns as the basis of an IR application because it's not domiciled. That intellectual property holding company won't be domiciled within the European Union. And unlike as an intellectual property holding company, it won't have a real and effective commercial presence there. Significantly, the corporate tax is 25, but you can negotiate that on a canton-by-canton basis, and you can actually get a lower rate. Another strategy, you're a US-based, or you're a US intellectual property owner. The majority of businesses within the Eurozone, member of the protocol, common law legal system, but no real and effective commercial operation in the European Union. Again, I would suggest using Ireland. Member of the protocol, so therefore can own and file Madrid applications. It's an Irish, it can also use any CTMs it holds as the basis of a Madrid IR application because it's based within the European Union. Your corporation tax is 12.5%, but you can actually get that down to 2% if you use the amortization rules over a 15-year period. Significantly, again, it's a member of the Eurozone, so therefore dealing with OHIM is going to be a lot easier. Same legal system as the USA, and it has a double taxation agreement with the USA. Lastly, let's say you're a Russian IP owner, majority of business within the Eurozone countries, no real effective commercial operation in the European Union. Russia is a member of the Madrid system, and it has a civil law legal system. I would suggest that if a Russian business wanted to set up an intellectual property holding company, the best jurisdictions would probably be Luxembourg and the Netherlands. They're both members of the protocol, so therefore any Russian-owned IPHC can own and file Madrid applications. A Dutch or a Luxembourg-based IPHC can use CTMs it holds as the basis of a Madrid because it would be based in the EU. And I understand that the corporation tax in Luxembourg can be as low as 5.17%. Luxembourg and Netherlands are both members of the both Eurozone countries, so therefore no currency implications when dealing with OHIM. And along with Belgium, Luxembourg and the Netherlands are all part of, as Edward said earlier on, they're part of the unified Benelux Trademarks Office system. And they both have a civil law system, so it would be probably more familiar to a Russian-based business. So my last slide is, you've decided you're going to set up an intellectual property holding company within Europe, and these are the factors that I would suggest you consider. Will that intellectual property holding company be able to use CTMs it owns as the basis of a Madrid IR application? Will the intellectual property holding company be located within a Eurozone country, important when dealing with OHIM? Is the parent company from a common law or a civil law country? You want your intellectual property holding company to be in a country with a familiar legal system. Does the ultimate parent originate from a country within the same language where the IPHC is located? You may have to take infringement proceedings in a country where language and legal system is not familiar to a parent company. Does the intellectual property holding company have a double taxation treaty with the country or the ultimate parent company? And lastly, do the tax advantages ultimately outweigh the disadvantage of not locating in a country where the management of an IP portfolio is easiest? So that's it. I'd be happy to take questions later on. Thank you.